Thank you for joining me today for the webinar, which I have called Out of the Mouths of Babes, Children's Wishes in the Family Court. My name is Belinda Jeffrey. I'm an associate with Michael Lynch Family Lawyers. A little bit about our firm. We're a specialist family law firm that has been established for 24 years, and we have over 11 lawyers practicing in our firm that can offer advice to people. My aim today is to share with you my knowledge of the following. What age does a child have to be? How do children's wishes fit into the legislative framework? How are children's wishes captured in the family court? What if parents' statements about the child's wishes differ? The role of an ICL and a family report in the context of children's wishes. The weight is applied to children's wishes. What happens at an interim hearing and final hearing? Some recent decisions dealing with children's wishes, and what this all really means in practice. And I'm hoping it's going to be helpful to you in your area of practice. I do want us to engage during this webinar, so I ask that you participate in some poll questions that I've put together. The first of which is, what age does a child have to be or to decide where they wish to live or how much time they spend with one parent over the other? If everyone could please put in their poll answers. A few things clients have said to me when this issue has come up are, teenagers can decide where they can live, surely. Can't Mary, who's 7, tell the judge what she wants to happen? She knows her own mind. Tom, 9, doesn't want to spend any time with Dad. Surely the court won't force him to go. My next door neighbour said that her daughter, who was 12, was able to choose where she lived. My girl's the same age, so the same applies. We agree that we would let the kids decide. Isn't that for the best? So looking at the poll results, I'm pleased to see that most of you have said no set age, and that is the answer. There is no set age until children turn 18 years of age and become an adult, where a child can choose with whom they live. But children's wishes certainly can be conveyed to the court. The Convention on the Right of Child, Article 12, provides parties shall assure to the children who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with age and maturity of the child. For this purpose, the child shall in particular be provided the opportunity to be heard in any judicial and administrative proceedings affecting the child, either directly or through a representative or appropriate body in a manner consistent with the procedural rules of the national law. This has been reinforced by our national law, which is the Family Law Act of 1975. Best interests of a child is the paramount principle when a court is considering the making of parenting orders. The court looks at primary considerations of the benefit of a child of having a meaningful relationship with both parents and the need to protect a child from harm. Additional considerations include, and this is where they've reinforced that in our area of law, that pursuant to section 60, capital C, subsection 3, little a of the Family Law Act, the court must consider any views expressed by the child and any factors such as the child's maturity or level of understanding that the court thinks are relevant to the weight it should give to the child's views. This should be comforting for clients to hear that children's views are considered, but it's the level that they consider. So my second poll question, which I ask you to participate in, are children allowed for court proceedings to swear or affirm an affidavit and or give evidence in court proceedings? I'll give you some time to complete that and then I'll give you the answer once I go through my slides and what answers they have. Children as reporters of fact pose a difficult problem for the legal system, as the system is fundamentally designed to test the evidence of adults. How the children's wishes are captured in the family court are through the following means: by affidavit evidence of a parent or other witness at the commencement of legal proceedings, by the judge speaking to the child directly, by application of a child seeking to become a party, by the independent children's lawyer speaking to the child directly, and by a family report conducted by a family consultant or private practitioner. affidavit evidence of a parent or witness in the case means that they file an application and affidavit with the court. Now, this could be the family court or the Federal Circuit Court. Evidence of the children's wishes is usually placed before the court through an affidavit of the parent. Children cannot swear an affidavit except where they seek leave to be a party without the court prior leave. Likewise, children cannot be called as a witness or be present during proceedings without a court order allowing them to do so. By a judge speaking directly to a child or children, this is exceptionally rare and it's not encouraged in Australian courts. It's not something that judges do here because they don't consider that it has any probative value, but it does remain an option, and it is something that could be agitated for if the right circumstances existed. By an application of a child seeking to become a party, so this is something that a child can do if they're of the appropriate age and maturity. They can directly instruct a solicitor to act for them in proceedings. And the Family Law Act does make provision for a child to be a party. It rarely ever occurs though. Direct representation is difficult because it is the solicitor who takes the child on to act on instructions from the child, and we owe them the same duty of confidentiality that they would have as an adult. It is also the solicitor who ultimately makes the decision whether or not a child has the ability to form sound and reasoned judgments and understands the consequences of their action. Most solicitors are hesitant to act unless there's independent third-party evidence that suggests that the child does have that level of maturity and understanding. So children coming and asking a solicitor can be something difficult and something that we struggle with in terms of giving them an answer why that's not possible. The more popular way that children's wishes are captured in the family court are by the appointment of an ICL. So an ICL is appointed by the court. ICLs are typically solicitors practicing in family law who have been approved to practice as ICLs. This is contrast with the direct representation that I spoke about just prior. An ICL is not the child's legal representative and does not act on their instructions. An ICL must act in the best interest of the child, but not necessarily act on the wishes of the child unless his or her wishes are also consistent with their best interest. The last way that it's most popular for children's wishes to be captured in the family court is by a family report. Now they can be conducted by a family consultant or an appointed private practitioner who undertakes family reports. So that can be someone appointed by the court or someone agreed to by the parties. That family consultant or that private practitioner then undertakes interviews with each parent and any relevant others, as well as observations of the children and at times interviews with the children. The family consultants are usually from a psychologist or social work background, and they specialise in the area of understanding family issues and put forward recommendations to the court about that. Coming back to the poll, the most popular answer has been yes, but there are certain rules. And that's exactly it. There are certain rules. So it's important that people are aware what they can and can't do. And that's why getting advice about this at the very beginning of any court proceedings, or if there are wishes being expressed by a child, it's very important because they need to be set out in material in an appropriate way or independent evidence sought to put that material before the court so that the court then takes up the view as much as possible about what the children are saying and expressing. What if parents' statements about the children's wishes different? Well, the Family Law Act makes it clear that both parents are responsible for the care and welfare of their children until a child reaches 18 years of age. And there is the presumption that arrangements which involve shared responsibilities and cooperation between the parents are in the best interest of the child. In saying this, this comes to my third polling question. Does one parent's view of the child's wishes have more sway than the other parent. Often we have a parent come to us as a solicitor and say that Johnny or Barbara have told them something, and that they have told Johnny or Barbara that they will do that and they will help them with that. And they seem to think that because they've said this and because the child has come to them, that that's something that the other parent should consider. So the poll has indicated, and just the last few results have come through, the most popular answer is no or very rarely. And that's right. No parent has more rights than the other parent. No parent's view on a child has more persuasive sway than the other parent. And the court is quite mindful about how evidence from children are gathered and what context the evidence from the children are gathered. The wishes of a child may be written into an affidavit of a parent. However, evidence presented in a parent's affidavit where it looks as if a child is trying to please one parent or a child has been put under pressure with a direct question will hold little weight. As such, when writing an affidavit of a parent or instructing a solicitor to do so, parents should ensure that the conversation had with the child is clearly explained to that practitioner, particularly that it wasn't inadvertently or intentionally influenced or was prompted by the child themselves. And as the parent, you remain neutral and supportive of their choices. And I think that's a very key thing. When affidavits are written, which is the evidence of that parent, if a child is expressing a view or has expressed a view, it's good to give context about how that view is expressed, especially as the other parent may not take up the point that's being said in the affidavit, and they perceive rather that one parent is exerting a pressure or is influencing the child in some way. To have that context of how that came out or why it was said or when it was said gives an added layer to the evidence, which the court might then consider when they're having regard to the weight. But also if there is an independent third party, say that family report writer or consultant, when they're considering the evidence, they could also take the child back to that and say, well, I understand you said this view. Why did you say this view? And look into that area of maturity and understanding of the view that they've expressed. The role of the ICL is something I wanted to explore with you today. An ICL must ensure that any views expressed by the child are fully put before the court in an admissible form, and that's through a family report. Pursuant to best practice guidelines for an ICL, a child has a right to establish a professional relationship with the ICL. There is an exception that there is an expectation that the ICL meet with the child if they're over an appropriate age and maturity. In saying this, it is not a practice that I've experienced most ICLs do. Most ICLs view that children are not of the appropriate age or maturity that they could meet with the ICL. It tends to be those children of teenage, 13, 14 or higher, where they will meet with them. And where they meet with them will be, and when and where they meet with them is something that will be orchestrated and conducted by the ICL. An ICL, in considering any wishes expressed by the child and steps to be taken in the matter, is to be aware of that each child will have a different emotional, cognitive and intellectual development, family dynamic and structure, sibling relationship, religious and cultural background. And children are vulnerable to external pressures when they're caught in disputes about their parents. This can exist within the same family. So when there are multiple children and they are being interviewed by a family report writer, or the ICL is considering how to best express their views, just because they're in the same family doesn't mean that they're experiencing the same things. Different children of different ages, different emotional capacity express things in different ways. And I'm sure you experience that in your practice. An ICL is unable to guarantee a confidential relationship between themselves and a child, as that is the direct representation model. So when I mean there is solicitors and clients, if it was a child, have a confidential relationship. Anything said to an ICL can be put before the court or used to then navigate the system and proceedings. They are expected to strive to build trust and respect in the relationship, and they should explain their role to the child. This sometimes has the effect that the child doesn't wish to then talk or engage with the ICL, but it's important that the role of the ICL is explained to them. How the children can have a say and make their wishes known, that it's possible where a child with sufficient maturity wishes to have direct representation to be a party in proceedings, how the child can contact the ICL, and the involvement of a family consultant to write a family report, including the nature and purpose of that report, how the report will be used, and that all parties will have an opportunity to consider the report. As I said, it's important that the ICL establishes that trust relationship, but does be clear about what their role is so that there's no misconception from the child if they do then speak with the ICL. In practice, it is the primary tool for bringing children's wishes before the court in an admissible format. So more often than not, when there are children's wishes being expressed and the children are deemed to be possibly of a mature age and appropriate level that their wishes should be given some weight, then a court will be inclined to appoint an ICL. And that is something that should be sought once that evidence is put before the court, so on the first return date or shortly thereafter. Parties can agree on appointing an ICL, but that appointment ultimately is at the discretion of the court and the judge, and the ICL is someone appointed by the Legal Aid Association. A court can order that parties participate in a family report, including making their children available by bringing them to session. A court can order a family report to be undertaken of its own decision or by application of the ICL or one of the parties to the proceedings. And so that's that second layer of getting the children's wishes out there and before the court so it can be understood. In that family report writing process, which I'm going to talk about now, it talks about what their role is to help you navigate your clients through that process. So the role of a family report writer. The court may direct a family consultant to give a report on such matters as it considers relevant and desirable to the dispute. Typically, this will involve them having regard to the Family Law Act and what we term Section 60, capital C. There's a whole number of those additional considerations, which I only mentioned one earlier, but there's about 13 or 14, and they need to consider those in their family report. Unless the children are infants, so 0 to 2, or there are some other special circumstance, example, a child has a disability which prohibits communication, the family consultant must ascertain the views of the child in relation to the matter and include the views of the child in the report. A family consultant, however, in their role cannot force a child to give a view. So whilst they may do a direct interview model with them or a child play model in order to get some views expressed from them, the child can't be forced to give a view, and the family consultant needs to set out how they obtain that view in the course of their report, if any view was expressed, and it will also note if no view was expressed. The Australian Law Reform Commission, Seen and Heard, which was published in 1997, offers some insight into family reports, and many of those recommendations in that report have been implemented. The statistics from that report suggest that family reports are prepared in 60% of contested children matter cases, and that do proceed to trial. The report also suggests that the family report is highly influential, and it prompted settlement and was followed by judges in approximately 76% of cases in which they are prepared. There is no recent statistics which look at the same parameters, but anecdotally, I would suggest those statistics are on the rise, and a family report remains highly influential in the judge's decision-making process. More and more often we experience that is the independent evidence that the judge is seeking. So even if there's not an ICL appointed, it is the tool that the judge uses in order to be able to assess and grapple with children's wishes, but also best interests of the children. Remembering that I said that they very rarely ever meet with children. And whilst that's an option to them, they just don't take that up, preferring instead to rely upon people in specialist field and their report in order to give them that information. What weight is applied to children's wishes? And I guess that's probably the more meatier question that you're asked time and time again by your clients. And indeed, it's something that we're asked more often than not. Unfortunately, as all good answers go, the answer is it depends. In considering a child's wish, a judge, an ICL and family consultant will turn their mind to the following: degree of emotional and intellectual maturity, apparent strength of their wishes. Do their wishes have a sound, rational basis? What is influencing the child's wishes, if anything? And is it wholly or partly due to manipulation by a parent or other significant person in the child's life? In considering a child's wishes, a judge, ICL, family consultant will turn their mind to the following: what is the likely impact on the child if their wishes are given significant weight? What is the likely impact on the child if their wishes are not given significant weight? And where there is more than one child, are there any competing or divergent wishes? Children's wishes, while they are important, can have a significant impact on the outcome of proceedings. They are only one of many factors which a judge has to consider in the context of any parenting matter. Ultimately, the weight to be applied to a child's wish is at the discretion of the judge hearing the matter. The judge is not obligated to make orders consistent with a child's stated wishes. Rather, they are obligated to consider the weight to be given to those stated wishes. And that's often a critical point that we need to reinforce with our clients. So whilst a child may express a view, and that is something that the ICL has put before the court or the family consultant has written about extensively in the family report and possibly even recommends that it be adopted, the ultimate decision comes back to the judge, and the judge needs to decide if that recommendation by the family report writer and or the ICL should be accepted and should be put in place. Now, they're going to have regard to the evidence by the other parent and any other significant others, and also consider that independent evidence. Often judges don't always agree with family reports, but it does still serve as the best form of evidence, and that's why they're more often than not ordered. One of the issues that I thought I'd raise as part of this, and I'm only going to touch upon it briefly, is relocation. Because when turning my mind to this topic and what you would be faced with in your practice, I expect that a lot of people are saying to you that the children are expressing a view about a change in residence or relocating. Relocating is not a separate sub-branch of any matters in child proceedings. So you don't file an application just about relocation. You would have to file it about all parenting matters. So what time and who they live with and special occasions. It has to be all encompassing. The term has been really adopted by family lawyers to describe a common situation where one parent seeks to take the child or children to live a considerable distance from another parent. Often there are legitimate reasons. They've got a new job or they've got a new relationship, and the result of it means that there will be a significant disruption to the time the other parent currently spends with that child or children, or could involve moving internationally or interstate, which would significantly affect their meaningful relationship. I raise it because whilst a child may wish to move with one parent or not, again, children's views will be considered in the same way that it would in another parenting matter. So it would not matter if the children were particularly for or against a relocation. That's not necessarily going to then determine the outcome of the relocation application that's before the court. There is no easy solution to relocation matters, but I think often children's views are not as critical in relocation as they are in other parenting matters. So whilst a view from a child is expressed, the court really needs to assess that all-encompassing what's in the best interest when considering a relocation matter. What happens at an interim hearing? I put a few slides in about interim and final hearings because how children's views are then dealt with at an interim and final hearing are quite different. And again, I think it's important that people understand the scope of what can occur in those occasions before the court. So interim hearings are held when parties cannot agree on arrangements for their children or property, and the court needs to make a temporary order or an order that certain steps take place before a final decision is made. The orders at an interim hearing will remain in place until there is another court order or the parties agree between themselves. An interim hearing may take place on the very first court date that it is allocated, when your documents are filed with the court registry, or if you are the respondent, the court date that the application has been given. Usually the evidence that the court can rely upon at an interim hearing is the evidence contained in the court documents which have been filed by the parties. That is, affidavit of the applicant or the respondent, affidavit of any other witnesses, documents attached or annexed to affidavits, information contained in a financial statement of the applicant and respondent. You can also issue subpoenas that could be returnable before that first court date, which then produces documents from third parties that may be relevant to an application. I raise this because it comes back to my earlier conversation and point with you that it's important to consider how the children's views might be conveyed in a parent's affidavit. If there is a view that needs to be put out there for the determining of an interim issue, then it needs to be thought about how's the best way to put that before the court. Is that in the parent's affidavit? Is that in another witness affidavit? Should there be an organisation that's subpoenaed to produce documents? Should there be a letter coming from a counsellor or from a doctor? Or should there be police records subpoenaed? They're just some thoughts I've had. Normally, the court does not require or allow any person to give oral evidence at an interim hearing. It is therefore highly unlikely that you would be required to answer any questions in the witness box or be required to ask any questions of the other party. So I think for people who haven't experienced court proceedings before, they think that that will be an opportunity that they're afforded at an interim hearing. It won't be. That is something that is done at final hearing and not on an interim level. Sometimes the judge will require additional information or clarification. These questions are discreet and can be answered by a party or solicitor, but will not be formally considered evidence in the matter. So it might be just to inform the court. If you want the court to take evidence into account, it all has to be in the form of an affidavit or financial statement that's provided to the court as an annexure to an affidavit, or otherwise they're not going to have that information before them. So it's not the case that a person can speak about this evidence or look to include it at a later point. What the court can't do. Firstly, the court cannot make findings of fact when facts are in dispute at an interim hearing. So I've given an example there. If one party's affidavit says, she always hit the children and I don't agree with physical discipline, and the other party's affidavit says, I never hit the children, it was my former partner who was responsible for discipline. The court can't decide at an interim hearing which of those allegations is true. Issues in dispute can only be resolved at final hearing when the court has the opportunity to hear from all witnesses directly by oral evidence. Secondly, the court can only make orders about certain types of issues. Those issues they have the power to make orders about because of the Family Law Act. Generally, the court can make orders that relate to the children or property of the parties, but there are exceptions to this. There are, for example, only very limited circumstances in which the court can make orders about child support. A court cannot make orders about where an adult must live. The court cannot make orders that force a parent to spend time with a child if that parent does not wish to. A final hearing is conducted by a judge or a justice being in the family court. Prior to the final hearing, the parties and witnesses will have filed affidavits. At the final hearing, the parties and all witnesses, including the family report writer, will give evidence and be cross-examined in relation to their evidence in their affidavits. A barrister will likely be engaged by each of the parties at final hearing to conduct that hearing. The barristers will make submissions at the conclusion of the final hearing, summarising the evidence, their client's case, and why the court should make the orders sought by their client. It is rare that the judge will give his or her judgment on the day of the final hearing. More commonly, the judge will reserve judgment and the decision will be handed down at a later date, usually 2 or 3 months down the track. Only about 3% of matters filed in court will reach a final hearing. And I find that statistic often shocks people. It can sometimes take over 2 years before a matter reaches a final hearing stage, and that's especially in the case of parenting matters because they can be complicated and that independent evidence needs to be sought. I raised about the 3% because, as I said earlier, a family report is often a tool that aids parties, parents, to reach agreement on what could be in the children's best interest. Having a third party suggest or recommend what's in a child's best interest, or for the first time confirm a child's view or not confirm a child's view, often enables the parties to then come together and consider that and maybe find a common ground or a neutral ground that they could then agree on arrangements for the future needs of the children. I thought this was an appropriate time to talk about some cases that have been before the court to give you some perspective on what they mean. So the primary authority in relation to children's wishes is the case of Bondelmont and Bondelmont. This was a case that went all the way to the High Court of Australia, and that's unusual. Not many cases do go through there. The facts of this case are, it concerned two boys aged 17 and 15 who travelled to New York with their father. During the trip, the father advised the mother that he would not be returning to Australia and that the boys had expressed a desire to remain living in New York with the father. The boys had previously been residing with the father in Australia. Their 12-year-old sister resided with the mother. So at this point, we've got father with the two boys in New York, mother and their sibling, their sister, here in Australia. The mother successfully obtained an interim order for the boys to be returned to Australia pending final determination. The father unsuccessfully appealed the interim decision to the full court of the family court and then to the High Court of Australia, citing that the trial judge did not give the appropriate weight to the views expressed by the children, this being the boys, so the 17-year-old and the 15-year-old. The High Court asserted that the trial judges had taken into consideration the views of the children. However, the focus played by the father upon the prescribed consideration stated in the section 60C, subsection 3, little a, which is that one about any views by children, tended to elevate the views expressed by a child to something approaching a decisive status. In some cases, it may be right, in the exercise of a primary judge's discretion, to accord the views expressed by a child such weight. But that section of the Act does not require that course to be taken. They are but one consideration of a number to be taken into account in the overall assessment of a child's best interests. In this case, the High Court reiterated that although a children's views and wishes can be relevant, they aren't the determinative factor, and there is no requirement for the court to be bound by those views. I think that's a particularly poignant statement by the High Court of Australia. It reinforces that whilst these children, 17 and 15, clearly were expressing a view, they were not successful in their view, at least on an interim basis. This isn't a final determination, but on an interim basis, they weren't successful in that view being given the weight that they necessarily thought it should and that the father thought it should. Instead, the mother was successful in it coming back to Australia, and then it was litigated before the courts towards final orders. The final outcome did see that the children remained living with the father, and there was agreement reached about where they live. But what I wanted to focus on is really about the weight and considering what weight it should be given. The next case I wanted to speak to you about is Boyce and Boyce. Now, this is a case from 2013, and it was a single instance judgment. So that means it's the first time before the court, before one judge, and it was of the Federal Circuit Court of Australia. This involved 3 children aged 18, 17 and 13 at the time of hearing. So they could have been younger at the time the application was made. The father complained that the mother and her new husband were responsible for estrangement from the 17 and 13-year-old, and I'm sure that's something you hear quite often in your appointments with your clients. Mother said she was just following the children's wishes. The 13-year-old was born with profound deafness, and the real focus about the children's wishes was on the wishes of the 13-year-old girl. The 13-year-old was resisting spending time with the father. In fact, at the time of hearing, she had not spent any time with him for a period of 10 months. The family consultant, so they went off and did one of these family reports, had formed the view that the mother and her new husband were not encouraging the children's relationship with the father. So the family consultant really gave that recommendation and view that the 13-year-old was being allowed to decide, and that the mother and the new husband weren't pushing or facilitating the time with the father. The family consultant noted that the child had consistently articulated a view that she did not wish to spend any time with the father, although it was also noted that she did not appear to fully understand the implication of her view. It was noted by the judge that the mother had willingly and willfully disobeyed court orders when she withheld the child from school, deliberately so that the father could not collect the child from school. Given that the child lacked that emotional intelligence and maturity in expressing her views, very little weight was placed on the wishes, and orders were made by the judge for her to have regular time with the father. So what about the older children? The court has no jurisdiction when it comes to a child of 18 years of age. They're then an adult. So no orders were made about that child. It was accepted that the 17-year-old, also a female in this circumstance, could make her own arrangements with regards to time that she spent with the father. So her views were very much taken on board, and that's what she expressed her wish to be. Coming back to the 13-year-old girl, what I take away from that case is looking at the context of their wishes. So going back to how are they forming that? Are they at that level of maturity to form that view? The actions of parents can also influence in this, and particularly in this scenario, how the judge then looked at the views of the child. So because the mother didn't do something, the judge was then somewhat skeptical about the weight that a view of a child could be placed. And the last case, because I'm sure you don't enjoy cases as much as I do, is Beckworth and Garnett, which is a 2017 single instant judgment as well. This case involved 3 children. That seems to be a bit of a theme. They were aged 17, 13 and 10. Again, you'll see that a lot of the children's wishes cases are in that age bracket. There is no set age, there is no parameters, but I do find in my own experience that people who have children between that kind of 10 through to that 17 is when children are becoming their own identities and they are expressing those views. So they are becoming more vocal, whether that's to the parent that they're living with or the parent that they're spending time with. They're starting to assert their own individuality. At the time of the interim hearing, the eldest child, who was 17, and for this purpose I'm going to call her Sally, was living with her mother, and Bob, who's the 13-year-old, was living with his father. Rachel, who's the 10-year-old, Rachel was the child in dispute. So she wanted to have more say about who she spends time with. And at that point, she was moving between both homes, so between mum and dad. When they were spending time with mum, Sally and Rachel had decided that they wanted to remain in her household and refused to return to the father's household. The father applied for what we term a recovery order, so seeking the return of a child to their habitual residence. And in this case, he would have been talking about Rachel because she spends time with him. They were successful. He was successful in having that order made. The matter was then set down for an interim hearing to determine for Rachel where she should live between now and a final hearing. Rachel expressed clearly that she wanted to remain living with mum, and there was evidence before the court to attest to that fact. So I can only assume in this regard that there was either a psychologist or a counsellor's report or possibly a family report that put forward that view. But there was evidence before the court that really reinforced the views of the child. Both the independent children's lawyer and the mother tried to persuade the judge that Rachel should be allowed to live with the mother in the interim. The father argued for a more cautious approach. The judge had to decide what weight to attach to Rachel's wishes. The judge found that Rachel's wishes were something that should be followed and something that should be considered by the court. However, the evidence before the court highlighted that her reasons for wanting to stay with mum were not very well grounded or mature. There was also a clear absence of any complaint about the father's household, and there was no suggestion that she was unhappy with the father. The judge also found that the mother had made significant complaints about the father, which appeared to be a gross exaggeration of the truth. The mother also lacked insight into her own behaviours and effect that that may have had on Rachel. In that regard, it came out in the evidence before the court that the mother's legal representatives had interviewed both Sally and Rachel, and that the court considered this outrageous, and the judge in this case ordered at interim that Rachel should remain living with the father. So again, how the evidence is put before the court, how it's obtained is quite relevant. Looking at the parties' involvement in obtaining that evidence is also quite relevant. What does this all mean practically? Children's wishes are important, but they're not the whole picture. That's really what you should take away from this. There is no set age until the child is an adult where a child can choose with whom they live. So no child is the parent, no child tells parents what they need to do. Although an older child may clearly express wishes and insight into the impact of those wishes, and it will most likely be given significant weight, it's not always a guarantee. Often with older children, a comment I make to my clients is that they do tend to vote with their feet. So once they are at that 15, 16, 17 age point, they are becoming more vocal and they will start doing what they want. And parents in some ways have to try and work within those parameters. That's more difficult when parents are separated and there's not a good co-parenting relationship. Younger children, research shows us, tend to want to stay with their primary carer, while older children tend to gravitate to the household with the most resources. So those with the PlayStations, those with the pools, those who maybe don't have the rigid rules, and maybe in this coronavirus situation, maybe don't enforce the homeschooling as much. So that's something that needs to be born and thought about when talking with clients. There is often caution surrounding a child expressing a view or wish because children are often people pleasers, especially in separated families. Children will tell parents what parents want to hear and not necessarily express the same wish to both parents. Children can be influenced by the views of a parent, and therefore the view they express may not necessarily be out of their own construction. And children are often not mature enough to be able to form and articulate a well-reasoned view about their future circumstances. So there are always limitations to those views. Sometimes resisting change does more harm than good. Not all children have a clearly defined view, and while almost all children wish to be heard, they often do not want the pressure or responsibility to make a decision or be put in a situation where they have to choose. A fact that unfortunately too many parents fail to understand. And that comes back to my point about the role of the ICL and also the family report. So children often, when they are told that it's not confidential and they will be reported in saying a particular view or stating a particular reason, they decline to have that view put forward. And in those circumstances, there's really little that can be done if they're not prepared for that evidence to go before the court. No child should ever be forced to give a view, and it may be that there are other ways that views can be explored apart from a child directly saying it. In most cases, it is essential to put information obtained from children before the court. Especially when children are older, their views and wishes are highly relevant to the determinations to be made by the court. And I do it often in my affidavits by clients. We do have to put forward views. But I'd say to you again to think about the context of that and to think about how those views are expressed. And I often ask my clients to show some insight into those views being expressed. Thank you for bearing with me. I hope you found that helpful, and I hope that you found that to be a guide when you're talking to your clients. I will open it up for questions, so if there are any questions, please post them and I can certainly then answer those. On the next slide, I have some contact details that set out my email as well as phone number. We offer a fixed fee initial consultation, so if your clients were wanting to have some more specific advice on their matter or could benefit from that, if they're thinking about court proceedings or thinking about how to approach a family law matter, please feel free to give them my contact details. And as I said, that'll be in the slide that follows. The last thing that I need to ask from you, and you've engaged so well with me, is I'd be very appreciative if you could fill in a feedback survey and give us your thoughts on today's webinar, and as well as any future topics that you might be interested in or how we can help you. We'll just check now whether there's any questions, and if not, no, that either means I gave a very comprehensive webinar, you've all fallen asleep, or it's really of no interest, this topic. I hope it's not that, and I hope you can tune into our next webinar. Thank you.